it's their turn to argue, they can just get up right up here.
Okay.
And I think, yeah, I think it's fine. Simpler that way.
She's last.
Okay, so it's good.
And then if your phone is disconnected, you want to leave that or disconnected also.
Oh, okay, yeah, my phone should be off. The audio connects here, but I've turned the audio off here as well.
And I don't hear an echo, so that should be good.
Okay,
Um,
perfect.
Yeah, and we can move the cameras around if it's easier if you want to do anything like that.
Okay, I'll see, Alejandro is my co-hearing examiner.
Okay.
He's coming in momentarily and then I'll see what he thinks. I'm fine with it as is.
Okay, I'll be here also.
Okay, that sounds good. Appreciate your help. It'll probably run until about noonish. So,
Here all day.
okay, sounds good.
All right.
Hello, Mr. Bagako, how are you? Good.
Where do you envision us?
The person who is arguing, I imagine they'll be here, otherwise anywhere in the back. I don't know how many attorneys are coming.
Right.
If it's only like 3 attorneys, then you guys could just sit right here, but
All right.
it's up to you.
It's weird. No, it's not that bad. I mean, it's great. Just.
We have a lot of flexibility, so
I have to do one of these.
yeah, we have a lot of flexibility on where we do the camera and all of that, so
Yeah.
however we want to do it.
And the monitors also.
Sounds good. Yeah, and like I said, Alejandro should be here and see what he thinks.
We could. These out, so.
Oh, yeah. I was meaning to do that.
And then the mic does stay live. If we left it.
Got it. That's good to know. All right, perfect. Okay, so Anna, I think we're on YouTube, so I think we're in good shape.
Yes, I'm gonna make you host again, okay?
Okay, sounds good. Thanks for all your help this morning.
Sure.
Ms. Hoyman? This is John Krankamp. I'm one of the hearing examiners. Just checking to see if you can hear me.
Good morning. I can, you're a little bit low, but let me try it on my end.
Okay, and I can move up my mic to be real close to me too, so
And actually, that just sounded a little better, so I think we're good.
perfect. Okay, well, we'll keep it. We will have one other we will have one other hearing examiner. And I'll make sure that he has his mic real close to him too. So we
Thank you.
appreciate all your work today.
No problem.
I was gonna ask you, the timing of it, the hearing is probably gonna run anywhere from an hour and a half to 2 hours. Do you have a
Okay.
preference? Do you have a preference on whether, when we start at 10, should we push through all the way, or do you want to take a break in the middle? Do you have a preference on that?
I don't, if we're only gonna go an hour and a half to 2 hours, I probably will not need a break.
Okay, all right,
So
well,
I'll
you-
leave that up to you.
okay, well, if you decide you need a break, just let me know and we can take a stop. So,
Thank you, sir.
thank you, appreciate it.
See you in a bit.
Good, how are you? Good morning. Good morning, Mr. DeSalen. Can you hear us? This is John Crankham.
Yes, I can.
Okay, perfect. And it looks like we have Hunter Holman on. I think he's from WRA. Is that the attorney for WRA or?
That's correct, yes.
Okay, perfect. Okay. Are either of you waiting for anybody else from your respective parties?
Nope, I
Okay.
think we're it.
Okay, that sounds good. Well, we won't get officially started until 10, but just wanted to make sure we were all present. Um,
Carol Lynch, Mr. Hearing Examiner Carol Lynch may be joining us.
Okay, that sounds good. I'll keep an eye out for her and admit her if and when she joins on.
Okay, thank you.
And just for the benefit of those who are remote, I think you can see Mr. Bogatko is present in the room. Gas Company is also present in the room.
Yeah, I think this is the way it's gonna look, so. like, you all-
Yeah, so the plan for those in attendance in person is that where Mr. Haverly, where he's sitting, that's where the argument will be delivered. And there's a microphone there and they'll be able to turn it on. We'll do the same thing for entries of appearance, again, for those that are in person. So unless anybody has any preliminary matters we should discuss before we start, before we actually get on the record, we'll go ahead and wait just for the next couple minutes. Okay, I show that it's 10 o'clock. Ms. Hoyman, are you ready to go on the record, ma'am?
Yes, sir.
Okay, perfect. Well, good morning. The time is now 10 o'clock. We are now on the record, and this matter before the New Mexico Public Regulation Commission will please come to order. This is the time and place set for the evidentiary hearing in the matter of New Mexico Gas Company's Integrated Resource Plan for the planning period of 2024 through 2033 in compliance with 17.7.4.9 NMAC, docketed as case number 24-00203-UT. My name is John Kreinkamp. I'm joined this morning by Alejandro Retigi Martinez. We are the co-hearing examiners presiding over this matter today. We are being transcribed this morning by a court reporter. And so for the sake of that record, I'd like to start with entries of appearance from the parties, starting with New Mexico Gas Company.
Thank you, Mr. Hearing Examiner.
And if you could come right up here and turn the microphone on, that'd be great.
You bet.
Thank you, Mr. Haverly.
Thank you, Mr. Hearing Examiners. Brian Haverly and Juliana Hopper on behalf of New Mexico Gas Company. In addition with us today are Tom Bullard, the Vice President of Engineering, Anita Hart, the Director of Regulatory, and Kyle Brayton, the Director of Gas Supply.
Okay, good morning.
Morning.
And next, Utility Division Staff, Mr. Bagaco.
Good morning, Mr. Hearing Examiner, Mr. Retigi Martinez, and our commissioners, John Bagaco. And I am here on behalf of the New Mexico Public Regulation Commission Utility Division staff.
Thanks, sir. Next up, Western Resource Advocates. I believe that's Mr. Holman.
Yes, good morning, hearing examiners. My name is Hunter Holman, appearing on behalf of Western Resource Advocates. Thank you.
Good morning. And last but not least, the Coalition for Clean Affordable Energy. I believe that's you, Mr. DeSalem.
Thank you, Mr. Hearing Examiner. Good morning, everyone. Charles DeSalen representing Coalition for Clean Affordable Energy. And also here is Kara Lynch, also representing Coalition for Clean Affordable Energy. And actually, Miss Lynch is the lead attorney on this case for CCAE.
Okay, perfect. Well, good morning to both of you. I will note for the record, there were no individuals or entities who signed up for public comment as provided by the procedural order. Now, before we get started substantively this morning, just sort of a recap of what we had put in our pre-hearing order, just for the sake of clarity. We have allotted 30 minutes this morning for each of the briefs in chief, meaning that Gas Company, then the combined brief of WRA and CCAE, and then staff in that order will all have 30 minutes each. As the side arguing first, Gas Company can reserve some of its time for a rebuttal. We will be asking questions of the attorneys during the argument. We are joined this morning by several members of the commission, the chair, and then Commissioner Aguilera. In the event that our questions, both from the hearing examiners and potentially from the commissioners, do require more than 30 minutes per brief, then we will provide additional time. But if we do allow time to one party, then we will allow the same time to other parties in the interest of fairness. I am going to try to keep time this morning. I have a little timer app that will be most advantageous, I think, for those appearing remotely. But I will give, for those in person, I will give 15-minute, 5-minute, and then 1-minute warnings, just so that you know where you stand. Just a couple of preliminary matters to address. The first one was we noted in our pre-hearing order that WRA and CCAE had the option of either offering one combined argument or potentially bifurcating their time between the two parties. So I'm not really sure whether to direct this to Mr. Holman or Ms. Lynch or Mr. DeSalem, but if any of you want to clarify what your preference is this morning, that'd be great.
I'm happy to clarify that. And for the record, this is Hunter Holman. I'll be making the arguments myself, so it'll be a combined argument today on behalf of both organizations.
Okay. Mr. Holman, I am going to ask if it's possible, if you could maybe speak a little bit closer to your microphone, that'd be great. I see Ms. the court reporter nodding her head as well. We can hear Mr. DeSalem fine, but we're having a little trouble hearing you, I think.
I'll see if I can resolve that right now.
Okay, no problem. And then we are joined, looks like just now, by Assistant Attorney General Gideon Elliott. Good morning, Mr. Elliott. Do you want to make your entry of appearance for the record? Looks like he might be having some technical difficulties. Mr. Elliott, if you are available to make your entry of appearance, that would be good. There is the New Mexico Department of Justice is also another intervener in this case.
Gideon Elliott for the New Mexico Department of Justice. My colleague may be in the room, Jocelyn Barrett.
Not quite yet, but we will look for her. So we'll let you know when she arrives. But thank you. Okay, so then the other preliminary question was to gas company. Mr. Haberly, do you want to reserve some of your time for a rebuttal? And you may as well take your place up at the mic.
Yes,
It's your
I'll go to
first.
the mic. Yes, I'd like to reserve 7 minutes, I think, for rebuttal.
Okay.
So I'll do 23 minutes of argument and then 7. of
All
rebuttal,
right,
if that would
so
be acceptable to the hearing commission.
Yes, that's perfectly fine. I'll go ahead and set your timer at 23 minutes. And then lastly, I guess before we get started, are there any preliminary matters from any of the parties that we should address before we start the argument?
Mr. Krankamp, is this volume better?
That is much better. Yes, thank you,
Great.
Mr. Holman. You're coming through loud and clear. Okay, seeing none, then we'll go ahead and start with gas company's argument. Gas company is going to reserve 7 minutes for their rebuttal. So that leaves 23 minutes. And Mr. Haverly, whenever you're ready, start your time.
Thank you, Mr. Hearing Examiners, who pleases the commission. We are here today on an analysis of a gas IRP. New Mexico Gas Company filed their IRP pursuant to the commission's rules 17.7.4 NMAC, and the filing was challenged in a timely manner. So the commission has allotted this hearing to discuss what are the requirements of a gas utility under the rules when filing an IRP, and whether New Mexico Gas Company's IRP filing meets those rules. The first thing that we look at is the contents of what the IRP is supposed to have, which is 17.7.4.10. And from all the briefings and the pleadings, I think the only things that are really in contention with 17.7.4.10 is C and D. I didn't see anybody argue A, B, anything past E, F, G, H. I don't think there was any argument on that. So I'm going to focus my analysis and my argument on first, did we comply, or the company comply with 17.7.4.10C and 17.7.4.10D? And then we can talk about 17.7.4.11B, because I think that's the other provision that's in contest today. I didn't see anybody say anything about A, so I think I'm just going to focus to those three aspects of the rule. Now, the first thing that I think is important when we look at those rules, and each one of those, 10C, 10D, and 11B, all talk about resource. All of them talk about the resources, and 11 even has it in its heading, where it talks about natural gas resources. I think that's critical, and luckily the commission has given us a definition of what resource is under this rule. And a resource is under 17.7.4.7H, a supply side resource, energy efficiency, or renewable resources used to meet utility systems. So pretty simple, okay? Everybody knows that what energy efficiency is. We also know that energy efficiency is also examined by the commission under 17.7.2 NMAC, as well as governed by the Efficient Use of Energy Act, which is 62-17-1 through -10. So we know what energy efficiency is, okay. Renewable energy, there's not a ton of it with the gas, but we know what it is. And then we have supply side. Well, supply side is not just a known thing, but the commission then, in its infinite wisdom, has given us a definition for supply side. So we have supply side, and that is 17.7.4.7I. And it says that it is a resource that can provide natural gas supplies to the natural gas utilities, transmission, and distribution systems. So gas supplies to the transmission distribution systems. That's what a resource is. And so with that thinking, then I think we can really have a good discussion about 17.7.4.10C. What that rule requires is that we provide a summary of foreseeable resources needed for the planning period being 10 years out. So we endeavored as the company to do that. We talked about in pages 15 through 18 of the IRP, what our gas supplies look like, what the challenges look like in the future, and the things that we're looking at. And the thing specifically that we said for gas supplies was storage on page 17. We talk about what has transpired since the Mexico Gas Company's LNG filing that was ruled upon by the commission, what we might be looking at going forward in terms of our storage position. And we talk about the things that we are thinking about and how we're going to go about that. Everything else is an acknowledgement of some of the issues that the company faces in procuring gas supply, different basins and different interstates, and how we have diversified that over the years. And nothing right now is necessary to do anything in addition for that time frame. We talk about renewable gas as a possibility in the future, pages 23 through 24. However, we acknowledge that renewable gas is expensive. It's cost prohibitive. And you have to remember that all these rules have to interface with each other. So why do we talk about renewable gas and being cost prohibitive? Because the PGAC, the Purchase Gas Adjustment Clause, mandates that the company find the lowest priced, reasonably secure gas. So we have to respect what the PGAC rule tells the company they must do in compliance with also the IRP. Because the IRP rule actually says, the commission thought of all these things. It's wonderful. 17742A says that the IRP does not supersede any other commission rule. It's meant to try to be read in harmony with it. Well, I will tell you the PGAC rule is very, very clear. It tells you that we must have the lowest cost gas that's reliable. And that's 17.10.60, 640.9B. That's the commission's rule. So we take that into consideration when we do these analysis. So we did that. Energy efficiency, we spend a lot of time talking about energy efficiency, pages 25 through 27. That's also governed by commission rules and a statute. We do every 3 years, we come before the commission and propose a plan. And the commission approves it or alters it and tells us the things that they think are necessary. So we've gone through all of these discussions and we tell everybody we have evaluated these potential resources. We don't need anything more from the energy efficiency program right now than what the commission has already approved. We're not looking for new resources. So we've done that. So we have actually complied with 177410C and provided summaries of what we currently have and whether we need new things. So the company's position is that 177410C has actually been met. Okay. So then we move to 177410D, which requires anticipated resources to be added during the planning period. Now, C and D to me are very, very similar. One seems to be a little bit broader of the things that you could foreseeably do. And then you, I think, are supposed to narrow it down with D and say what you actually anticipate doing. And so we, again, have answered this and we try to talk about the storage, the contracting opportunities, things on the gas supply side. And we do that in 15 through 18, specifically storage we talk about and contracting we talk about on page 17. So we go through a similar analysis and we talk about that's the only anticipated thing that we will be doing. We will be doing something there, but we don't have numbers yet. This is kind of far out in the future. We have our current gas supply and storage situations, and those are not going to be changing anytime soon. But we recognize that they could change and we need to do analysis, especially coming out of our LNG filing and the commission's decision there. So it's acknowledgement that more work is going to be done on that. So we tell the commission that, yes, we are doing these things. And I don't think it should be lost that this is in reality a compliance filing. This is meant to provide information to the commission as what I would call a heads up over the next 10 years of things the commission can anticipate seeing from the company. If there's a big shift in the gas supply requirements, if there's a big shift in storage coming, if there's a big shift or issues that we are seeing now that we are going to need to deal with, we should be letting you all know. And that's, I believe, what the purpose of the IRP is. Approving an IRP gives the company no ability to automatically recover anything. That approval process merely says you've complied with giving us information that is useful for us to know. Now, I do want to get one thing off this table, which is we did mislabel our IRP. When under 177410H, we're supposed to give the commission any other information that may aid the commission in determining what we need to do in the future. And so we view that broadly. And we gave a bunch of information about distribution and transmission projects. We unfortunately put it under the heading of anticipated resources to be added. That was an oversight on our part. We admit that it does not go under, those discussions are not resources. Those distribution and transmission lines do not meet the rule or regulation definition of resource. They were a mislabel. They should have been put under 17.7.410H requirements, and that was our fault. And to the extent that caused confusion, we apologize for that.
Now, council, so first of all, you're at 14 minutes. I should have given you a 15 minutes up, but you have 14 minutes remaining. So 410D, it does refer to these anticipated resources to be added during the planning period. It also calls for the evaluation of various options that could reasonably be added to the resource portfolio as well. So it, you know, as I would see it, it essentially requires two things. Can you tell me what part of your brief or what part of your IRP includes that evaluation?
So we don't have an evaluation per se, because most of what our resource mix is going to be stagnant. It's going to be static, not changing at all. We're not planning on changing our basins or our suppliers or our contracts. We're evaluating those things. We continue to evaluate those. Storage is a long-term issue. Any storage move that we're going to do is going to take, as the commission has told us earlier this year, significant analysis. If we want to change up our resources for storage itself, we need to come to the commission with a very, very robust analysis. And we listened to the commission on that. We don't have that analysis done yet. And that's going to be going into the future. We anticipated when we started this process that LNG was going to be a highlight in that, in our future resources needed. The commission decided that in our case that was not going to happen, and they gave us their reasons, and we understand those reasons. So we haven't done an analysis to pivot from LNG to something else. We do have long-term storage, and we acknowledge that we have these possibilities going forward, but we haven't done that new analysis. We did analysis for an LNG compared to a lot of other things. The commission disagreed with us on that. We respect that. But there isn't any new analysis that we have done or is really to be done in that time frame that we could bring to bear for a 10-year idea of what we would do going forward with storage. And we acknowledge that this is something that is going to take us some time to do. We had put all of our eggs in the basket of the LNG, and we did provide analysis as to why we were doing LNG in that case, and the commission disagreed with us, and that's okay. But there is a ton of evaluation that we did, but it would be kind of silly to just take everything from that case, drop it in a compliance filing. The commission knows all of the information. This is really a vehicle to provide information to the commission. They know all that stuff. They've ruled on it. We're moving forward. This is a forward-looking document. And we said, you know what? Based on that denial, we have some more work to do, and we're going to do that. We're filing the IRP because we're told we file it every 4 years. So here's the best information we have at the time. But anything else is we don't need new things. We don't need new interstate pipelines. We don't need new interconnections with interstates. We don't need any of those things. So there was nothing to evaluate there.
All right, so let's turn to 4.11, because I think that I have more questions about that than I do 4.10, frankly. This phrase "as appropriate" is obviously the phrase that's discussed in everyone's briefs. You know, how we're trying to interpret that phrase. One of the questions that I didn't see addressed, frankly, in any of the briefs, although it was cited in staff's brief, was the role that the IRP statute plays. Because it seems to me that when we look at this particular rule, and you know, we can discuss whether that whether the rule itself is vague or, you know, requires further interpretation. But do you have an idea of how the statute fits into your interpretation of the rule?
So I think the statute is broad, and it's meant to be. I mean, all statutes are generally supposed to be broad to give the commission the flexibility to find, as an expert agency, to make the determination of the information that is really necessary for the commission to enforce the statute in order to bring the goals of the statute into existence. I actually think that the way that this works out is you have, and the statute is broad because it's also trying to cover all the energy utilities, right? And it's doing it in one section. So the commission then promulgated 2 different IRP regulations in order to harmonize the fact that electric companies are different than gas companies, and you have to make those determinations independently. The statute doesn't do that. It broadly just talks about you should go do these IRPs and you should think about these things. The commission and its expertise has recognized that the gas utility is different than the electric utility. And I think that actually is important to talk about, because the commission recognizes, I think, in their rule that the as appropriate language, as you said, means that there's not always going to be something for the gas company to evaluate on a regular basis. The gas utility is just a different animal than an electric utility. The way that it functions, the way that energy is produced, the way that the markets work, everything is different between the two. So I think that while the statute gives that broad framework for the commission to do something, the commission decided to provide a more detailed requirement in order to satisfy itself of what the utilities need to do. And I do think, as you said, the as appropriate language is key here. It's an acknowledgement by the commission that some of these things aren't going to be appropriate. And I can talk about why they're not. I mean, renewable energy, as we talked about, is very expensive. It's not cost effective within our portfolio under the PGAC. So the commission has already said, well, while that exists, it's not appropriate to do it. It'd be futile, honestly, for us to do a multi-level analysis of renewable energy when it is trading at 40 therms compared to $2 a therm for natural gas. It's way outside the boundaries. And we say that it is just not cost effective. So we could do all kinds of analysis that would ultimately always resort in the idea that it's not cost effective under the PGAC. We can't do it under the IRP. Is that something that the commission finds useful? I can't imagine it is, for us to spin our wheels and do various modelings and provide hundreds of pages of model outputs to show that $40 gas is not better than $20 gas or $10 gas or $2 gas. I mean, there is something that the utility brings as its expertise. The utility is in the gas markets every single day. It is buying gas. It doesn't create its own gas. It doesn't have wellheads. It's in the market. It knows all of these things. It would be a waste of the utility's resources and time, the stakeholders' resources and time, to have it go through and march through an analysis of renewable gas and trying to bring out a crystal ball of where that renewable gas will be in 10 years compared to where it is right now and when it might be actually cost effective.
Mr. Haberly, thank you. I want to make sure I understand gas company's position on the analyses discussed in 11B.
Mhm.
It seems like gas company and the protesters, interveners agree on the point that the IRP does not include the analyses discussed in 11B. And the controversy is whether those are required. And gas company's position, in part, is that it's not required because of this as appropriate language, which the company contends gives the company discretion to decide whether the analyses are appropriate. Why does that language, which I agree needs to do something, why does that give gas company, rather than the commission, for instance, the discretion to decide whether those analyses are appropriate?
I think there's a couple of reasons. And you're right. That is exactly our argument. You've restated it beautifully. Our position is that as the expert, we are tasked with running the utility. Again, we're constantly in the gas markets. We file energy efficiency cases. We are involved in this aspect every day. We do actually understand all this information. And to the extent that there is something that we can bring to bear, we tell the commission. And you have to trust us at least a little bit to run the utility and to manage the utility. And we come forward with the information that is appropriate without, to use a phrase, spinning our wheels for no reason. And there has to be some discretion that the company gets to bring to bear, because otherwise it's an infinite cycle of alternatives that never really bear out. They become futile. So, sorry.
Allow me to follow up on that. Is it correct then that the IRP does not contain the evaluations? And, I was looking in the IRP for an explanation of why those evaluations weren't appropriate. And I don't know that the IRP contains that either.
So the IRP contains not we agree that we did not do the analysis that would be required under 177411B in terms of doing multiple analysis in various scenarios and various levels. We did not do that. It does not contain that. We agree with that, first and foremost. Second of all, the reason that we didn't do it is because, and we tried to say this and we didn't do a great job, and I agree, we did not do a great job, but like for the renewable energy, we talk about that it's cost prohibitive. In our energy efficiency, we give 3 pages of energy efficiency, but in that, and it's buried, I understand that, but in it, you can actually see that we're talking about the fact that it has already been approved by the commission. And that's where I was going to go with the other point, is that all of the things that we're discussing here, the commission ultimately sees somewhere else when we're actually asking for a remedy of some sort or a relief of some sort. We're in for rate cases, asking for capital. We're in PGAC cases. We have PGAC filings. We provide all this information to the commission in various places where the statutes and the regs also want it. And it's all before customers pay for it.
Council, how, one of the things that I'm a little bit confused about, just from reading your brief and also from reading staff's brief, how do you determine that this evaluation is or is not appropriate? I mean, what would you look to? And I guess a related question, what would the commission look to in order to review your decision as to appropriateness?
So what we do is we do a year-long analysis where we take these things into consideration and we look in the world and we see, but we also have our energy efficiency case is already on file with the commission. So we already take that in and we plug that in. The commission already knows everything about our energy efficiency case. Load management, we look at that, but the commission also knows about the load management already. We've recently litigated that issue and the commission's already made a determination in 22-00309. We didn't feel the need to repeat that determination about load management. We could have. But again, this is a compliance filing. We viewed this as not as something that would be litigated, that we'd have to make a prima facie showing. We needed to comply with reporting requirements. And so that's where we went to reporting requirements. Could we have done a little bit more, a better job of organizing everything? Absolutely. We admit it. We have some work to do on organizing our IRP to make it very clear as to what we're doing and why we're doing it. But the commission actually gets a lot of information from us writ large in all of our proceedings. How does it know that we've complied with this? Well, we talk about the fact that renewables are expensive. Energy efficiency is limited in terms of what it can do going forward in the future. I mean, we didn't do this, but if you do the numbers, the energy efficiency program yields about a 0.16% savings of gas on a peak day. That's all it does. So we're not even getting to a 1% savings. If we did a full bore, we used all the statutory money we could, it'd be 0.16% of gas savings. That's not something that we felt like we needed to do further analysis of.
So, Mr. Haverly, I guess one of the related items on that point was, it struck me, one of the questions that we had asked for briefing on was this question of, is there any issues of fact in this case, right? That was one of the issues, and all of the parties responded saying, no, there's no issues of fact. So I was a little bit surprised in your brief in chief, which then was cited in staff's response, that you cited to rebuttal testimony from a prior case to make your point that this analysis of load management was not appropriate. And when you cite testimony in your brief to make your point that it's not appropriate, to me, that sounds like a question of fact. Am I wrong on that? It seems like this argument as to whether or not it's appropriate, the way that you're couching it, it almost sounds like a quintessential question of fact, and you have 1 minute remaining to step.
So in general, I would normally agree with that statement that if we were bringing testimony to bear, but this is testimony that has already been taken in another case. It's already been examined. The commission has already ruled on that testimony. I think that makes it different. I don't think that it requires this tribunal and this group of hearing examiners to reevaluate what the commission has already ruled in relation to that testimony and has already adopted. I mean, the commission has already determined in its final order adopting the recommended decision in that case that that testimony was correct, that there isn't that ability. So I don't think that's actually bringing in a question of fact. That's already a finding the commission has made. And I don't think that's a new finding of fact that needs to, or new fact that needs to be discussed or evaluated.
And I'm just going to pause you just there, just to note that your time has expired, but we have more questions for you. So what we're going to do is we're going to give all the parties an additional, let's start with 5 minutes.
Sure.
We're gonna give all the parties an additional 5 minutes, because we still have other issues that we need to ask you about.
Sounds fair to me.
So I want to turn to the, principally the due process argument that you make.
Yes.
So assuming that that the present interpretation of the IRP rule is the company's interpretation. Company makes the argument that there's a prior practice or standard that the commission cannot diverge from without adequate notice. So just a couple points on that. The first is, what is creating this prior practice or standard? What precedent can you point to that's creating this practice?
So that when we talked about that, we were talking about the fact that we have done, and I think everybody agrees with this, the prior IRPs that the company has filed in 12 and 16 and 20 contain very similar information in a very similar format and did not contain the analysis as the hearing examiners have talked about in this case. They did not contain that analysis at that time either, and those were all found compliant. The company engaged in a year-long process with stakeholders and analysis and other things based on the fact that its 3 prior IRPs in this format had been approved. We did not go out and locate new software, new modeling issues. We didn't go out and get new quotes for lots of things that we already knew were not feasible because we're in the business every day. If we had, we would have needed to have done a lot more work and spent months, many more months, honestly, doing stuff.
But I think the point here is not so much, I mean, your point is well taken, but the question is more about the fact that, I mean, you don't have like a prior, is there an order or a final decision order, a recommended decision, any type of actual commission consideration of these issues? Because I think what I think the facts are, and what I think the rules are talking about is essentially that these filings are deemed compliant, deemed accepted as compliant with this rule. And so I think that and I don't want to speak for my fellow hearing examiner, but I think that's more the question. Is that sort of inaction a precedent?
And I'll give you a little more context for that, because I was looking over the due process precedents you cited and others. And in each of those, there's an order from the commission or a series of orders from the commission that's creating that precedent. So I'm wondering if you have, either a Supreme Court precedent or prior commission precedent for the proposition that the commission's inaction can create a standard that justifies this reliance, or in the alternative, a commission order that carries the interpretation that you're putting forth in this case.
Sure, I don't have a Supreme Court decision that says that a simple operational law activity that gets carried over time and time again and then changes, it constitutes a due process argument under Hobbs gas or electric. There's always an order. I do agree with you. I don't have a citation to anything like that.
And then the, similar on this due process issue, on notice. So let's assume that this is that the commission's prior inaction has created a practice or standard that we can't diverge from without notice. Why is the notice that was provided through the protest and at the outset of this case insufficient? And, I'm thinking about Mountain States, where the notice that the court deemed adequate in that case, it didn't come until, during the proceeding itself and staff and intervener testimony.
Sure. So, whether and how it will rise to that issue is interesting, and I've thought about it. I think what the company's position is that this being a compliance filing is a little bit different than a normal litigation where you file testimony, somebody else files testimony, then you have rebuttal, and you have this fight over, and you expect to have a fight over all these things, and that you do work throughout the process. We show up today in a completely different arena. It's a compliance filing. And yes, the commission absolutely has the ability to tell us that we were not compliant with the obligations. However, when we have been operating for a year, putting this analysis together based on the idea that the commission may accept the proposed IRP as compliant without a hearing, and that, yeah, we've done that, and we said, okay, nobody ever protested anything in the past, and now we are here before you with a year's worth of work. And we would have to more or less throw out a lot of what we've done and redo it and have, honestly, I think you want us to have new stakeholder meetings and other things to talk about this analysis, if that's really what the rule requires, because we've never thought that it did.
And can you just elaborate on those potential burdens to gas company? Like what are the consequences here?
So the consequences, depending on what evaluation we have to do, is we're gonna have to buy software that we don't have right now to do all of these various analysis at different levels. I don't know if it's going to go quite to a pro plan level analysis, but we're talking about expensive software that somebody's going to have to license, and we're going to have to get people that will run all of these scenarios. I mean, I don't want to get into, because it's not a fact issue before you, but for the idea is that we would have to do things and reevaluate and redesign our entire process of how we do the IRPs, because it hasn't been triggered that we need to do that analysis ever before. The commission has accepted that the company is an expert in some of these areas and that some of these analysis were not appropriate at the time. So we've never had to gear up to do them. Every year, 4 years, when we gear up to do them, we make that analysis. Do we need more people? Do we need more consultants? Do we need more information and to bring to bear to this? And so far, the answer has been no. We've been happy with our gas supply portfolios, which is really what this rule is aimed at. It's not a capital program, and it's a gas supply portfolio program.
I want to go back to this, I think, distinction you were drawing about sort of this proceeding being a little bit different in terms of this due process concern. And, I spent some time looking at the case law in your brief. And in particular, this El Paso Electric Company case from just last year, the Supreme Court case. And if I read that right, it looked like in that case that the reason that the court found that EPE had not been given a proper opportunity to respond was because the commission had deviated from its past practice without that issue having been raised at issue in the case, essentially. That this was not an issue that was raised in testimony or essentially in briefing. And what I thought I heard you just say was that this is quite a bit different from a case with testimony and whatnot, because you'd have to go back essentially to the start and essentially redo this. And I guess that gives me pause because, if this was, for instance, a rate case and, the commission again was looking to deviate from its past practice, and the commission were to deviate at the request of a party going through testimony, and then essentially you would have to go back and redo your application. I guess I'm not really seeing why that would be so different from the case at hand here.
I think it is, and the reason is the difference in a litigated case where we understand the need to make the prima facie showings, and the commission doesn't really deviate from those in terms of here's what the rule says you need to do. Now, sometimes there are arguments and they go all the way to Supreme Court. I think the Four Corners abandonment case was one where, well, did they make the showing right or not? Did they bring enough evidence? But that wasn't that was an initial interpretation rule. There wasn't precedent for it. But I think when you have a compliance filing like we have here, that is a different animal, because in litigation, you're prepared to fight about all these different aspects. Everybody that's ever filed a rate case has years of these experiences, and we all know that there are things that will be moving, and you have to have models that do all these things. There isn't a clause like the one in here where it says as appropriate do these things. No, in rate cases, in CCN cases, there is a list of requirements. You meet them. And if the commission says, okay, well, I want you to meet it that way. Okay, well, then you've done modeling, and you do have the opportunity to change and explain why that change is acceptable or not acceptable, is flawed, is not flawed. Here's the results. Here's the information. In this case, we've done all of that information on reliance to the last 3 IRP cases.
So just FYI, you have 1 minute remaining. My question to you, I guess, would be this then. Let's just say, hypothetically, obviously the two of us do not have the last word on this. The commission does. If the commission were to look at this and say, you know what, the commission has been improperly interpreting this rule in the past. Where does that leave the commission? Would it have to revise the rule? I mean, what recourse would it have if it can't deviate even after this litigated proceeding like this?
So I think so that's a very interesting question. I think really what it comes down to is the commission has to give all of the stakeholders and the parties at issue some type of notice. Now, is that a rulemaking? A rulemaking is excellent notice. I don't disagree with that at all. That brings all the stakeholders together. Everybody gets to understand what's going on. Everybody gets to have a voice. The commission ultimately makes a decision. That's a very appropriate area. But I think if the commission were to make a declaration of how they're going to plan to interpret the existing regulation, and they do that in some form where it is provided to all of the utilities that are subject to this, which is not the case by making a decision in a single case. I think the Supreme Court is very strong, especially in the El Paso case, about having a decision in one case not affect all the other utilities. That is not sufficient notice. So I think there are ways the commission can actually provide that notice outside of doing it within a contested IRP, and they can communicate that information going forward to everybody. And now, excuse me.
Well, that's your.
Yes.
Just because we're on this topic, I do think maybe just a little bit more time here. Thinking about what, following up on my co-hearing examiner's point, what is the commission to do here? 15A provides this process where the commission can identify deficiencies and, give instructions for refiling. And under your interpretation, both of the rule and, with the understanding that this is a compliance filing, when would the commission, under what circumstances could the commission identify deficiencies and send it back for refiling? Or is that sort of dead text once the companies submit IRPs, so long as their most recent IRP is identical to what they submitted before?
So I think that where the commission has that power is important in 10. If we had omitted an area that we were supposed to cover, if we had never said anything about renewable energy, and clearly that's one of or energy efficiency, if we just omitted that from one of our filings, I think the commission say the resource definition requires that it was absent here. Please go back and add that resource to the mix. I think that's where we're talking about that. So
That was one of the questions I was actually that was an example I was going to give you. So let's say hypothetically, you're not the only gas company. Let's say hypothetically the next IRP that comes in, somebody does exactly that. They omit in 10 one of these clear content requirements. The commission, for whatever reason, doesn't catch it. Right? They come around the next time. Is the commission at that point, if they make the same error again, is the commission prohibited from essentially telling them that they need to refile because this error that the commission made previously essentially has bound their hands?
No, I don't think so. I think that those are errors. Now, if you say that, especially on a one-time aspect, I don't think a one-time ruling would bind the commission at all. I think there could be a very easy explanation for the fact that the rule clearly requires this. There isn't any leeway for that discussion. You have to acknowledge that the possibility of energy efficiency. If you don't discuss energy efficiency, you're not going with the rule. In this case, I think we're in a different area because the rule says as appropriate, and what's the determination of as appropriate under 11B? And I think that's really where our entire fight is here today. And the commission has decided, at least from the company's viewpoint in the past, that the company had some discretion on whether they had to do these massive analyses and whether that needs to change today or not. And that's really, I think, where the fight is. I don't think that it's because there's something that is clearly a requirement that's listed in the rule gets omitted and then the commission catches it later. It's a question of how much discretion does the company actually have here and whether this is mandated no matter what. And I believe what the argument of the counter is that we should do all the analysis and just say each one is appropriate or not appropriate, rather than the company's interpretation of, which is why go do something that we know is completely inappropriate at this point. And so that's where the rub is. And what the company's position is the commission has recognized in at least 5 cases before this, that the company, again, not in an order, but by accepting as compliant 5 different IRPs from gas utilities, absent that analysis, that the utilities do have discretion. And by by the belief that we have discretion, we did actually carry that into these IRPs, and we did rely on that idea. Thank you. Thank you, sir.
I think the method of the other parties. Gave an extra 13 minutes.
You're breaking up.
Sorry, I did not have my microphone on. We, just for the benefit of the parties, we gave Mr. Haverly 13 minutes of extra time, so the parties now have 43 minutes, give or take, to make your argument. And I believe that brings us to Mr. Holman, arguing on behalf of WRA and CCAE, if I'm not mistaken.
Yes, thank you, hearing examiners, and may it please the commission. I believe I'm going to benefit from Mr. Haverly's introduction, so I might just dive right in and more or less agree with Mr. Haverly's characterization that the issues, the regulatory provisions that are most relevant to our protest here are 410C, 410D, and 411B. So I want to start by addressing some of the comments that Mr. Haverly made. It's our position that the IRP process is far more than just a compliance filing. This is the opportunity for the utility to engage in an analysis of alternative resources under different cost and risk scenarios to identify. I'm sorry about that. I believe my camera just shut off for a moment. This is the opportunity for the utility to engage in an analysis to explore alternative resources for resource needs that it identifies pursuant to its IRP. This is sort of a foundational concept of resource planning generally. You identify resource needs, you evaluate all of the applicable or appropriate resources that could satisfy that resource need, and then you identify the best resource from that evaluation that serves customers. And essentially, that's what these three regulatory provisions do. 410C requires a summary of foreseeable resource needs. Identify the resource needs that the utility is going to plan or procure resources for over the planning horizon. 411B requires an evaluation of alternatives under different cost and risk scenarios on a consistent and comparable basis for the purpose of identifying the most cost-effective resource portfolio. And that evaluation must be based on a present value revenue requirement analysis. That is a requirement.
Yeah, let me jump in at this point. So I guess my main question I think there's some textual support for your characterization of this process, but the fact remains, as gas company has pointed out, this really isn't an instance, is it, of one filing that sort of missed review. They're making the point that essentially there's this pretty standard practice going back now years. He characterized it as 5 some filings, and whether that's right or not, I don't know. But can you address how should that impact our review of your argument in this case?
I think the authority analysis supports the commission's ability to follow its own regulations and issue refiling instructions to address deficiencies. I think there's a clear distinction between some of the due process cases that the utility cited in its briefs and the instant case here, because for example, in the Hobbs case, they were engaged in a changed methodology that was retroactively applied that had monetary effect on the utility. That is a practice that the utility constructed moving forward, changed the practice, and then applied it retroactively. That's very different from what we're doing here. We are engaged in the process that has existed for over 10 years. To say that the utility had no notice that somebody could protest its IRP on the grounds that it is inconsistent with the regulatory requirements is just to say that they didn't read the regulations. They've been around for the entire time they've been filing these things. So we are engaged in that process. And I think to say that because the commission has not identified these issues, or a protester in the past has not identified these issues in the past 5 IRPs, they're precluded from doing so in this one, at least to the extent that it only applies prospectively, I think undercuts the validity and the purpose of the protest process in subsection 415A, and also the commission's ability to submit refiling instructions to cure those deficiencies should it or a protester identify deficiencies. I think if you were to identify that there was a regulatory practice I still think that the fact that a due process issue might exist is not sufficient. You have to engage in an analysis to determine whether or not the burden on the utility outweighs the interest of having an IRP that complies with the regulatory requirements that exist in regulations today. So I think if you engage in that analysis, you have to take into consideration the fact that the utility was on notice that what we're doing today was a possibility from the start. I think you also have to take into consideration the fact that the commission, stakeholders, and the public have a clear interest in a transparent, complete IRP from the utility so that they can understand what the utility is doing, what resources it's evaluating, what resources it's not evaluating and why, and what costs that means for the customers. I think, yeah, that's what I would say.
Thank you, Mr. Holman. So, and it sounded like that mostly addressed the, assuming that there's a past practice, that there's the due process concern should not outweigh the commission's ability to do something different here. I just wanted to, understand your position on gas companies' past practice argument. Do you agree with gas companies' characterization that their, series of prior IRPs, the prior IRPs of Raton and Zia also omit the analyses that this IRP omits that you contend should be in there? Do you, as a matter of looking back at those past IRPs, do you agree that they contain the same deficiencies?
I would have to say that I have not evaluated those past IRPs to the extent that I could give you a definitive answer, but to the extent that those IRPs were generally consistent with the information that has been filed in this case in New Mexico Gas Company's IRP, I would argue that they are also deficient in the same ways that we've argued in our protest and in our briefs.
Well, and let me direct you to the actual protest that originally was filed by WRA. And this has been quoted, I think, in Gas Company's brief, that NMGC has filed IRPs under the statute since 2012. That makes this 2024 IRP the fourth such plan filed under the New Mexico Gas IRP rules. The 2024-2033 IRP follows much the same format and information as the 2012, 2016, and 2020 iterations. I think that's sort of the crux of Gas Company's argument. If we were to determine that that has been the commission's past practice, where do we go from there?
I think if you establish that there has been a past practice, you go to what I just mentioned, which is an analysis of whether or not the interest of maintaining that past practice outweighs the interest in making sure that the IRP complies with the regulatory requirements today. So just because a past practice has been established is not the end of the story. I think Hobbs indicates quite clearly that there is an analysis that needs to be done to determine whether or not the due process claim outweighs the interest in the new or more appropriate, I would argue, interpretation of the legal requirements. And in this case, I don't believe that the gas utility going back to refile its IRP in such a manner that complies with the regulatory requirements outweighs the interest in having a complete IRP that transparently shows the commission, stakeholders, and the public what resources it's evaluated on what terms and why it chose the resources that it chose.
So let me ask you then, because I asked Mr. Haberly this question about the language in the rule that talks about that the commission, it's deemed accepted as compliant with this rule. So there's really no commission order or recommended decision on this point as much as it's deemed compliant. Do you have a stance? I don't recall that really being addressed in your brief. Is that a factor that we should be considering as far as whether this establishes a past practice?
I think you should consider it. I think a deemed acceptance is an acceptance. I think it's better if you have a decision outlining specifically why the commission is accepting something or not. But I don't think the issue is whether or not the deemed acceptance carries the day. The issue is whether or not you're going to give full effect to the entire section of code. A deemed effect of a previous case should not subvert or make superfluous the provisions of the regulation that say a protest can be filed, deficiencies can be identified, and the commission can issue refiling instructions to cure those deficiencies. So from the perspective of whether or not a past practice has been established, I think you can do that, but you also have to weigh whether or not, if you establish that a past practice exists, are you rendering certain provisions of the regulation meaningless? Because nobody the commission could not issue refiling instructions if that were the case. And, I think ultimately the case that we're dealing with right now is different enough from the instances in which the commission or the Supreme Court has established that an agency has engaged in a past practice that a party reasonably relied on, to the point that we are just simply engaged in a process that has existed for the entire time we've been filing gas IRPs, and the utility has been on notice of that. And we are not asking the commission to install any new language, any new requirements, any new analysis. We are simply asking the gas utility to file an IRP that contains enough information for the commission to determine, and for other parties to determine, that it complies with the regulatory requirements.
Okay, so then let's shift to the meat of this, and let's go to the actual interpretation of the rule. And I'm going to direct you to address 4.11, if you would, because that's the language that I'm most looking at here. 411B, that's not to limit you. You can certainly talk about 410, but what does the phrase "as appropriate" mean in this circumstance?
The phrase "as appropriate" is a modifier indicating that an analysis of certain enumerated resources in 411B is not necessary if that resource is not appropriate for a particular resource need. The preceding clause.
How do we determine if it's appropriate? Or how does gas company determine if it's appropriate?
I think that's the heart of our argument, is that gas company can determine whether or not a resource is appropriate in whatever way it wants, but it has to provide an explanation in its IRP to explain why it decided something was appropriate or not appropriate, so that stakeholders who might want to file a protest or the commission can determine whether or not their evaluation of what is appropriate is reasonable. That's
Okay.
what's missing from this case.
So to understand your position, so then, as we read 411B, it says that the utility shall evaluate as appropriate renewable energy, energy efficiency, load management, and conventional supply side resources. So if we take those sort of four pieces, in my understanding, your interpretation would be that gas company can effectively decide that evaluation is not appropriate for any of those four items. But to be compliant with the rule, they still have to put in some reference to that or some explanation of that into their IRP. Is that your argument?
That's right. But I think it goes beyond that, because the evaluation applies to supply side resources just as much as any other resource. So there are several other requirements underneath that first clause of the first sentence, which are missing from the IRP. So if gas company decides energy efficiency cannot meet a particular resource need identified in the summary of resource needs, fine, explain why it can't. And if you've identified a supply side resource that can meet that resource need, then what cost and risk assumptions did you evaluate it under? And is that evaluation underlied by a present value revenue requirement analysis, also as required by 11B? I think one of the things to remember about this particular subsection of the rules, and I think one of the most problematic components of gas companies' interpretation of the clause "as appropriate," is their interpretation is that clause allows the gas company full discretion to decide without any explanation, we're not going to comply with this because these resources don't apply. And I think Mr. Haverly said today, the issue is trust the gas company, because the gas company is the one that's engaged in the market. But regulation can't just trust the gas company. The whole point of having this required evaluation with specific components that need to be considered relative to each resource and a PVRR analysis underlying that is so that we don't trust the gas company. Their evaluation might be perfect, but we need to see that to evaluate it, to make sure that they are looking at all resources. And I think, as I said, one of the most troubling things about their interpretation, which allows them to essentially read out this requirement, is that these are the provisions that are consumer focused. These are the provisions that ask whether or not resources that might benefit consumers more than just another supply side option are actually being evaluated. This is the provision that requires the gas company to show customers what their preferred resources will cost. right? So if they have the unilateral discretion to just exclude this from their IRP because we need to trust them, I think that's a flaw in the process. And frankly, I just think it's inconsistent with the regulatory language and produces an absurd result.
Swinging back to the due process issue. So you talked about, even if the commission finds that there was a past practice created by accepting the prior IRPs, the commission should do a weighing burden analysis. Can that analysis be done without an evidentiary proceeding?
I think so. I mean, I think really the issues on either side of the scale are the utilities burden in, as Mr. Haverly said, going back and refiling its IRP, maybe conducting some more analysis, potentially having additional stakeholder sessions. I wouldn't say that that's necessarily required, but that might be, the extent of their burden. And on the other side, I think stakeholders inherently have an interest, as well as the commission and just the public, in having an IRP that complies with the regulatory requirements. So I think based on that alone, the balance comes out in favor in requiring the gas utility to refile its IRP. To the extent that you want to go further and evaluate, as some of your questions were alluding to, whether or not load management is a resource that should have been evaluated for a particular resource decision, that might be an issue for fact, right? We might have to dig into the specific resource needs and the unique characteristics of those resource needs relative to the alternative resources to determine on a fact basis whether or not, for example, geo-targeting of load management or energy efficiency could sufficiently reduce a resource need to the point that you don't need a supply resource. So I think, in my opinion, you don't need a factual hearing, but you may want to if you want to dig deeper.
So Mr. Holman, let me ask, sorry that we're sort of shifting back and forth between arguments here. I'm gonna take you back again to the 411B and the interpretation of that subsection. One of the questions I asked Mr. Haverly is this question about the IRP statute and how that should impact our interpretation of the rule. This is not something that was cited in your brief. But I mean, it's just looking at it from my standpoint, seems like something that I would need to address in a recommended decision. Can you give me your perspective on the statute and whether or not it is helpful at all in terms of interpreting our rule?
I think it's helpful insofar as it supports our interpretation of 11B. 11B requires them to consider energy efficiency, load management, renewable energy, supply side resources. The statute requires the same. It requires utility integrated resource plans to evaluate renewable energy, energy efficiency, load management, some resources specific to electric utilities, but it requires it to happen, taking into consideration risk and uncertainty, these things. So we didn't cite the statute because we felt the regulation was more specific to this task, but I think they're very consistent. I think the statute requires what I talked about at the very beginning, which is this concept, which is innate to resource planning, of identify your resource needs, evaluate all appropriate resources that can satisfy that need, and choose the one that's best for customers. I think that's what the statute is trying to create, and I think the regulations emulate that very well in a more specific way that applies to gas utilities.
Well, relatedly, as I interpret that rule, I have gone through the other provisions of the IRP, this Title 17, Chapter 7, Part 4, the IRP rules for gas utilities, and there's a number of different rules in here, and it seems to me that just going through these. This phrase cost-effective portfolio of resources appears a lot. And it seems to me that also is highly relevant in terms of how we would interpret the rule. I don't see your brief too much address that either, but Is that part of your argument that, in context, those other rules should shape our interpretation of 411B?
Without diving into the specific rules, I'd be hesitant to give you a definitive answer, but to answer, hopefully answer your question in a slightly different way, I think the cost-effective provision in 11B is one of the most important provisions of the gas IRP regulations, and I think I did put this in our reply brief, because that is the clearest indication of what the IRP process is supposed to do in regulation. It is supposed to identify the most cost-effective set of resources. And so to the extent that the IRP filed does not do a good enough job of evaluating alternatives under different cost and risk assumptions or explaining why it didn't consider those alternatives, I think you can't be certain that the resource portfolio that's identified is actually the most cost effective because the analysis isn't there.
Thank you.
Mr. Holman, I'm wondering if you can touch on gas company's argument that the nature of the commission's review of these IRPs is that of compliance. How hard a look can the commission take at an IRP given the compliance review that is provided by the rule?
I think first and foremost, the commission can determine whether it has enough information to decide whether or not each of the regulatory requirements is satisfied. That is an informational review, but there is some wiggle room, in particular in 11B, specifically with regard to whether or not the resources were compared on a consistent and comparable basis, specifically with regard to whether or not the analysis that was performed for present value revenue requirement was done sufficiently, things like that. That might require an evidentiary hearing to determine, but I think that's contemplated by the regulations today, in that if a protest is issued and the commission determines that the protest has valid points, you can have an evidentiary hearing to determine whether or not what the utility provided, for example, specifically with regard to whether resources were evaluated on a consistent and comparable basis, was sufficient to meet the requirement established in 11B.
So it sounds like you're describing something that is more searching than a, check the box to make sure all of the items are satisfied, but instead, particularly with regards to 11B, a hard look at whether the evaluations performed by gas company were sufficient. Is that correct?
That's correct. I think this process is one of the few times in which the utility can engage in a robust analysis of all of the options over an extended period of time in a transparent way to give the commission stakeholders and the public a better understanding of what it's doing in terms of planning to meet customer load and to meet customer demand. If that doesn't happen in a meaningful way, then this one opportunity for that transparency goes away. So it's not just to check the box, as you say, it's a do a hard look at your system within the confines of the regulatory structure and explain to us why you've decided on the course that you've decided on. I think Mr. Haverly mentioned in his comments that they don't plan on incorporating any other resources, and I hope I'm paraphrasing this correctly, but he can remind me if I'm not. The gas company doesn't plan on deviating from its supply side plan moving forward. I think that's a problem. I think the gas IRP is the forum for them to explore that and to explain to people why that's not cost effective or why that doesn't sufficiently hedge the risks that their system is subject to. I think this is the time for people to be able to see what's coming down the road at the gas utility. I also would say it's my understanding that this provision hasn't been used to great effect, but 415B does establish that if a resource type is in an accepted resource plan, that it creates a presumption that that resource is required for the public convenience and necessity. So I think the regulations, despite it maybe not being used to profound effect, the regulations do contemplate this having profound consequences for purposes of resource procurement if the utility decided to use it.
I don't have any remaining questions for you, Mr. Holman, and I don't believe my colleague does either, but you do have another 19 minutes if you want to keep arguing, or if you want to offer a summary, it's totally your decision.
I think I'll just provide one short argument and then kind of summarize my comments. The utility raises an argument that transmission and distribution resources are not subject to the IRP process. And that argument largely rests on the definition of resources and on supply side resource, specifically that those definitions don't include transmission and distribution resources or capital improvements. But I would argue that there is language in 11B, specifically the consistent and comparable comparison of alternative resources, that does require including the cost of transmission distribution system resources in the IRP. Namely, if you're comparing a supply side resource that would require capital improvements to either the transportation or transmission or distribution system, those costs have to be compared to, for example, an energy efficiency measure that you're using as a comparative resource. Otherwise, you're not comparing resources on an apples to apples basis, which can't satisfy the consistent and comparable language in 11B. So to the extent that you're evaluating resources against one another, you do need to consider the costs of capital improvements to the transmission or distribution system for purposes of satisfying 11B. I think to summarize as briefly as I can, this is really a case of whether the utility filed enough information to comply with the regulatory requirements. We are not asking for any specific analysis. We're not asking for new requirements to be read into the rules. We're simply asking for the utility to file a resource plan that does what the regulations say it needs to do. And I find it difficult to believe that they weren't on notice that a party such as Western Resource Advocates or CCAE could have filed a protest asking for the commission to issue refiling instructions correcting those deficiencies. That's been part of the process all along, and we find it to be in the public interest to let that process unfold naturally and see where it goes. I'll leave it there.
Thank you, Mr. Holman. I appreciate it. Okay, so it is now 11:12. Mr. Bogatko, we're gonna take a 10-minute break if you're okay with that, sir.
All right.
All right, we're gonna take a 10-minute break. We will come back at about 11:25, 11:20-ish. And we'll be off the record for now. Thank you.
I'm good here. Okay. I like when yeah, well, we do have room if you want to ask questions. No, I thank you for letting me be here. No, it's not, no, it's not, the storage, it would be very like that. Yeah.
Yeah, looks like it.
Give it another minute. Okay, looks like we have counsel for all the parties present. Only person we're missing is Commissioner Aguilera. I think we probably get started. All right, we'll go ahead and get started. Ms. Hoyman, if we could go on the record. Okay, the time is now 11:22, and we are back on the record after our 10-minute break. We've just finished with the combined argument of WRA and CCAE. We have now the argument from the Commission's Utility Division staff, Mr. Bogatko. As I mentioned to Mr. Holman earlier, we gave the gas company an extra 13 minutes for their argument. So you have 43 minutes to use as you see fit, sir.
Thank you, Mr. Hearing Examiner. Am I coming through all right?
You're coming through loud and clear, I think.
You know, I thought since we've agreed what the meat of this case is, and we've sort of honed down to the central issues, I might start off by just doing a little cleanup based on some of the questions you asked previously. Regarding the discussion about precedent on past practice, you had referenced the El Paso case that we recently got back from the New Mexico Supreme Court. And when I read that, I paid particular attention to the part of that case there. It's on paragraph 23, where they talk about the prohibition against changing practice without proper notice. They use the word practice, but also there when they talk about 62.6.14c, they also include the word procedures, which I think if we're trending towards just wanting to apply that prohibition to litigated cases where a record's developed, we may exercise a little more caution, because you'll note in our gas IRP rule that we've been talking about so much today, there in 17.7.4.15a, we were talking about that a little earlier, and that includes the sentence there that talks about how the commission can send the IRP back if it does not comply. Well, you'll note in the first sentence how it encapsulates what we're talking about. Number one, there in A, it's entitled compliance review. And then it goes on to state, the commission will review the utility's proposed IRP for compliance with procedures and objectives set forth herein. And I would submit that what we've been focusing on there in 7.4.11b is a procedure that has been interpreted by the utility in the past to essentially be discretionary. And as we've been talking about, what does as appropriate mean in that body of law? And that's the interpretation and the understanding of that procedure that the utility's been operating under. And so if we're now in the position of perhaps deploying a different interpretation of what is contemplated by as appropriate in that context, I think we need to be very careful about how we do that.
So, if, and Mr. Bagaco, to follow up on that, one of the questions that I had asked Mr. Haverly earlier was, again, let's say that the commission does ultimately determine that WRA and CCAE are right as far as substantively what 11B requires, in terms of maybe requiring additional analysis, or if not additional analysis, then some sort of statement as to why the analysis was or was not done. In light of what your interpretation of the case law is, where would that leave the commission?
I think it devolves then to an analysis under what's been presented in this case as to whether or not the utility's determination that it was appropriate to dispense with those analysis was correct and supported. And they have discussed that in their briefing, and they have alluded to it somewhat in the IRP, though, as counsel for the utility discussed earlier, you know, the IRP is, I think it says a lot of things and it covers a lot of substance, and I still take the position that it's compliant. But to be clear, and in all fairness, it does not contain like a certification of compliance or non-compliance with 17.7.4.11b.
So I do want to have that discussion, and I do want to have the discussion of, you know, this whether in fact substantively it did comply with 11B and as appropriate and whatnot. But I guess my question to you is, again, going back to the case law, if the commission were to determine that, hey, WRA and CCAE, they're right in terms of what the rule requires and the information that the IRP needs to contain, but we can't, in this case, let's say, require a refiling here, where would that leave the commission? Would the commission have some sort of an order for future IRPs that, hey, this is the type of information that's going to be required? Do you have to go through a rulemaking process to change the rule? I mean, where would that leave the
I think
commission?
at the very least, it would require some order that spread of record, gives proper notice to all interested parties. Ideally, though, I think it's something that would need to be resolved in a rulemaking, because this IRP for gas utilities is written the way it is for a reason. And I have reviewed the statute that is the basis for these rules. And the difference between the gas IRP in terms of content and complexity compared to the electric IRP is remarkable. But I think that's a reflection of the reality that what the gas utilities do in comparison to what the electric utilities do are the difference between, you know, dogs and cats or anteaters and sloths. It's a homogeneous product on the side of the gas company. We're not looking at like the multitude of different combinations of generation resources that we encounter on the electric side. I mean, it's a pretty straightforward proposition. They source and procure the gas and they deliver the gas. And then variations on customer end use. I don't know that there are that many compared to what you see on the electric side, where you have differences in voltages, you have differences in infrastructure, you have potential differences in all the generation resources. You know, coal, not so much anymore, but that was there for a while. You have natural gas. Is it just straight natural gas turbines, or is it a combined cycle? Are we talking about geothermal?
Well, I agree that, you know, I think any reasonable person, I think, would look at these, the rules, the IRP rules for gas and the IRP rules for electric utilities. There's a huge difference. They're almost incomparable. But let me ask you about one of the differences that I see between statute and the rules for gas IRPs. And in particular, whereas this, you know, language we've been talking about in 11B, the utility shall evaluate as appropriate renewable energy, energy efficiency, et cetera. It looks a lot similar to the second sentence of section 62-1710 that says utility integrated resource plans shall evaluate renewable energy, energy efficiency, load management, distribution generation, conventional supply side resources. And again, the language mirrors that, except for the phrase as appropriate.
Correct, and I'm not checking my
That's-
text. I'm
No, I
looking
know.
at the statute on my phone.
I'm not chastising you for using your phone, Mr. Brigago. I'm just saying the phrase that's missing is as appropriate.
Right.
So that's where my head is. What, the fact that the commission has added that into the rule, what does that mean?
The rule writer is recognizing then that it may not be appropriate to consider renewable energy, energy efficiency, load management alongside their conventional supply side resources, because the economics of those things may not have come along far enough to make it an analytically meaningful analysis. I mean, is there an economic comparison? If you already know at the outset that, let's see, how did we discuss that? I believe New Mexico Gas characterized the proposition for renewable energy as prohibitively expensive. The difference on several orders of magnitude between what they currently have in terms of supply and what renewable energy for natural gas is currently priced at. Energy efficiency, based on their representations, is maxed out so as to make it not meaningfully comparable, economically speaking. And then going to load management, they reference what happened in the case 22-00309 UT, which was the LNG case, which load management was characterized by the hearing examiner in that order. And I believe it was carried by the final order as basically being a non-starter for purposes of that analysis. And so based on the on-the-ground situation, taking the lay of the land, and understanding that these things are essentially non-starters in terms of comparable economic analysis for meeting the goal of this provision, which is in order to identify the most cost-effective portfolio of resources to supply natural gas to customers, it would be an empty exercise. I mean, not to be disrespectful, but it would be an exercise that wouldn't arrive at anything meaningful compared to like what you get with production cost modeling in the electric cases.
So let me ask you about that, because, you know, in your response brief, you did a lot of that same analysis, right? You went through each of those and talked about, you know, essentially what gas company has explained. And one of the things that jumped out at me, and I asked this question to Mr. Haverly, is, you know, in his brief in chief, and then you, in your rebuttal brief or your response brief, you cited to that, you know, you talk about there's a direct testimony that's quoted there. And you also use the phrase under these incontrovertible facts. Where my head goes, which I think you know, just based on the look on your face.
I know.
My brain goes, if these are incontrovertible facts, is there a question of fact?
Perhaps a better choice of words would have been appropriate in that instance, recognizing what's contained in your order. But I'll tell you, the way staff views it and the way I understood it was, it's not them taking heed of a factual controversy. It's them heeding the signal that was communicated to them in the resolution of that case, the LNG gas case. And with that signal, meaning like, this is kind of like a non-starter in terms of the prospective economic analysis that might be contemplated by 411B. They use that to inform their decision that under those circumstances, then it was not appropriate because it wouldn't advance the ball in any meaningful sense for purposes of determining the most cost-effective portfolio in those circumstances. And so again, we go back to as appropriate, which the way I read it, I mean, it could be the discretion of the utility, but I think it's more than just that. I want to do this or not do this. It's as appropriate as informed by the facts or circumstances. Will we have an analytically meaningful analysis of these things under the circumstances, given where they are economically or, you know, their feasibility, otherwise speaking? Would it be, would they even be economically comparable to begin with to even make this a realistic option?
So again, you use the phrase facts and circumstances, but I'm not gonna push you on that. What I want to ask now about is discretion. So we've heard Mr. Haverly talk about that. We've heard Mr. Holman's response. Tell us what does staff think about this argument about the discretion on the part of the utility, and what's the commission's role?
I think the discretion means whether or not it's feasible or warranted or something that should be incurred in terms of expenses for doing those production cost modeling runs. Also, I think the gas company indicated earlier that, you know, given the way things have been going and how their situation is static, so to speak, they don't have the software. But I think never minding that for the moment, it's the actual characteristics and facets of what's presented and whether or not it's appropriate that I think is informs their decision. Now, for what the commission might do with that, I guess to be fair, the commission could pick a bone with them about not having anything in the IRP that says why they did or didn't go along with what's contemplated by 7.4.11B. That would be a helpful signal, but I also understand the way that they've structured this. And so when you look at 7.4.11 A and B, I mean, it's evaluation of natural gas resources. You go above that to 7.4.10, it tells you what the contents of the gas utility IRP are supposed to include. And that's sort of like your recipe there for what must go into an IRP in terms of categories. And then following on that, 7.4.11 is discussing, I think, the analysis that accompanies or could accompany the presentation of those items as appropriate. What the commission does with that, I think they need to analyze and determine whether or not they're satisfied with what's now been explicated in terms of why a gas company did not conduct those cost-effective portfolio analysis pursuant to 7.4.11B, which is set forth in gas company's briefing. And they do cite to, you know, they do have explicit, specific reasons for the determination that went into their as appropriate analysis in that instance.
Thank you, Mr. Bagaco. You know, just to want to make sure I understand your position, it sounds like you agree with gas company's argument A that, you know, whether to perform these analyses and include them in the IRP is at their discretion. And then you also agree that they exercise their judgment here appropriately in not performing those analyses because, you know, they wouldn't have been cost effective, they wouldn't have been helpful, et cetera. Is that correct?
Correct. And I think the state of the gas utility industry, at least in New Mexico currently, is such that those points of analysis for purposes of that production cost modeling, for lack of a better term in this instance, have not come along far enough right now for it to be a meaningful analysis. So that's why they passed on it. And staff understands that, and staff is still accepting of the IRP. I would say, though, as an attorney, and you know, if I had to write this IRP, I think it'd be a lot more clunky and boring than it is, because I'm a simple man and I have simple tastes, and I would have just had a section that just went through each requirement lockstep and said where we were with it. And then, you know, the way it reads, though, it's good prose, and I understand why they've done this, because it's not for nerdy attorneys like me to consume. It's a public document. It's intended to communicate as best as possible, given, you know, the terminology we have, the concepts of what's going on with the gas company, with interested public and their consumers.
So can I just following up on that, you know, you agree with gas company, the way that they've exercised their judgment to not perform some of these analyses. And it seems to me like, you know, a lot of the rationales that they provide for not performing these analyses are coming from briefing in this case. Is it plausible that the drafters of this rule, even if they were giving gas company the discretion to decide whether these analyses were appropriate, is it plausible that that this rule intends for that explanation to be included in the IRP itself?
I've asked myself the same question and I've gone through this thing probably way too many times now from my poor old eyes.
I mean, it seems to me that that's what WRA and CCA, isn't that what Mr. Holman was just saying? But, I mean, even if gas company can determine in certain circumstances not to do these analysis, that the plan itself has to include some statement of that.
I mean, it's right there in 7.4.15A, compliance review. The commission will review the utilities proposed IRP for compliance with the procedures and objectives set forth herein. One of those objectives I would say is 7.4.11B. And so I think it would be at least helpful to have touched on that, to indicate, you know, we are dispensing with the analysis, and B, because currently it is not appropriate, given these three categories are, you know, economic non-starters or otherwise postured so as to not result in a meaningful portfolio analysis. That would be helpful. I think in this instance, though, I wouldn't want to penalize gas company for not having that express provision because of, you know, this has been a good approach. It's been a learning experience. And I think what they've represented in their briefing, I don't have any reason to doubt what they've said in terms of why they deemed it not to be appropriate based on those factors. Sorry to use the word factor.
No, that's not where I was going, but here's where I was gonna go with that. So what you just said was based on what gas companies put in their briefing, you know, you looked at that and determined that that was reasonable. Now, when gas company comes back the next time that they file an IRP, how would staff be able to make that determination as to whether it's appropriate if you don't have a protest from WRA or CCA?
Correct, and that's why I think maybe we're at the jumping off point for some kind of a rulemaking or something where we can put a finer point on what's contemplated by this, because obviously we have interested parties, and I know WRA and CCAE are vigorous participants in our other cases. And so I imagine that we have 4 years until the next one's due from gas company. Maybe, and I hate to suggest it, but maybe a rulemaking is in order, and with the input of all interested folks, including the other gas companies and folks such as our other participants here today, maybe that could be resolved. Because you're correct. I mean, the statute that leads to the creation of this IRP rule for gas companies seems to frame it in a shall do position versus what we end up seeing here as appropriate. And I'm not privy to any sort of the Scrivener's notes or anything else that went into the formation of these rules, but I think somebody was paying heed to the lay of the land for gas companies and the propriety of, you know, is it proper to force them to run production cost modeling when their situation is probably pretty static or homogeneous, or the things that would factor into cost-effective portfolio analysis are not yet in a meaningful position to be of consequence to that analysis.
Yep, Paul.
I have other questions.
So, you know, it's maybe shifting gears a little bit to gas companies' due process argument. Mr. Haverly, I'll have follow-up questions for you on this point as well. One of the, aside from the substantive, what does the rule mean argument, I think the consequences of gas companies' due process arguments have, you know, they're pretty large in scope. And the reason for that is the structure of commission inaction leading to this filing is deemed accepted or deemed approved. That is not just in this IRP rule. That is, our rules are replete with that exact structure. The commission does not do something on this filing, it is deemed approved. So, you know, from staff's perspective, seeing not just this case, but cases across the subject matter areas that we regulate, do you have concerns about the consequence of the commission not doing something on a filing having a precedential effect that it sounds like we can only revisit in a rulemaking?
I think I have mixed feelings about that. I mean, I understand why we have the dead man switch in so many of our statutes and our rules because I think it inures to administrative efficiency. And if something is kosher and it's been reviewed, there's no reason to hold it up, then it should be allowed to go into effect by operation of law. I think though that that's done on a case-by-case basis. The specific facts, circumstances, substance of the filing are reviewed on a case-by-case basis. And sometimes there are provisions in there that, you know, say, hey, staff, weigh in on this. And we'll do either formally and informally. And if staff sees no issues and no issues are drummed up by the commissioners and their advisory staff or our esteemed hearing examiners, then the pathway for that going into effect is to just let it go into effect. But I think the distinction there is on a case-by-case basis. So because you had one particular thing go into effect, it is not going to be exactly the same or as identical probably to another one that follows on and is allowed to go into effect. And even if like there is a tremendous amount of similarity in the two, they are separate filings. They're made at distinct and separate points in time, triggered by different requirements. So I think staff's position would be that under those circumstances and given it that is a case-by-case basis determination, that I don't think there should be a knock-on effect. I don't think they should be treated as precedential in that sense.
And so just to kind of draw out the distinction between staff's position and gas company's position, and Mr. Haverly, you can correct me if this is misconstruing, but it sounds like gas company's position is because the commission has accepted this prior IRP, it can't diverge from that without prior notice. Staff wouldn't adopt that as necessarily a rule, but more the commission could revisit this interpretation, but in these circumstances, it's not appropriate.
I view it more as don't change the commonly accepted or understood or established meaning of what's meant by as appropriate in that provision, which as I currently understand it, and we've applied it to staff, means, you know, it's their judgment call.
Yeah, I mean, again, I come back to this question. You said, you know, the established meaning or the understood meaning of that phrase. Is it understood if it's never been litigated before?
Well, I think working from staff's perspective, and that's what I'm primarily doing in my work here, is just that's how they review it and understand it and appreciate it. I mean, and it's hard for me to envision how else to understand it, given that its position in the sentence. I mean, I suppose it could appear somewhere else, but somebody prioritized that modifier and put it up there up front. I think to quickly get it out of the way that's, you know, their call, whether or not to do the production cost modeling in any given instance or not. So it's, that's how we view it. So maybe everything I say is in the context of my work with staff. Commonly understood, okay, I take your point if it hasn't been litigated or established, but we're operating also on the plain meaning as we perceive it of the provision and its modifier of as appropriate.
So, yeah, and this, I guess, is going to take us back to that discussion of the interpretation of that rule. This gets at a question that I asked Mr. Holman, but do you have all of the rules in front of you for the IRP, part 4, essentially, for gas utilities?
I do.
Okay. Because there's several points in here, and again, this is sort of the question I was getting at with Mr. Holman. There's several points in here that outside of 11B suggests to me that there's an understanding here that this analysis is going to happen. So first, let me turn you to the definition of an IRP and 4.7B. And it says a public utilities plan to meet New Mexico jurisdictional retail customers' existing and future demand, which for New Mexico gas utilities incorporates the evaluation of supply and demand side options, goes on from there.
Correct.
That seems to suggest that there's going to be an evaluation start. I'll turn you to 4.12C. Look at that last clause there, that the purpose of this public participation process are to develop the most cost-effective portfolio of resources for the utilities IRP. Again, I read that as suggesting that there's an evaluation, and there's one last one. And that's 4.14, this notice of material changes. The commission used the phrase, you see this here, the results of the utilities IRP. It uses the word results. That seems like, again, I go back to this interpretation of 11B. And as I look at the rule in context, it looks to me like there's an argument that you can make there that it looks like the commission is presuming that this analysis is going to get done. Am I interpreting things wrong?
I could see how you'd see it that way, and I've looked at it from that perspective too, but I'm also proceeding from the perspective of the specific controls over the general. And there are other things in here that are attendant to the so-called results of the IRP, including, as you'll see in 17.7.4.15B, where it ties the results of the IRP, albeit loosely in comparison to the electric IRP, to CCN or other procurement proceedings. And unlike the electric IRP, we don't have an RFP process in this thing. And so part of the cost effectiveness question is covered by our jurisprudence on gas utility CCNs, as you probably noted from the final order that came down in the LNG case, articulating it. And then there's a sentence there, if I recall correctly, that says, this could be amended going forward to, basically be tightened up somewhat. But that's also another avenue for review of cost effectiveness in terms of what's brought forth in this gas IRP. And so I see what you're saying and I take your point, but I would defer though to the specific, and I would think, intentioned inclusion of as appropriate there in paragraph B of 7.4.11.
Well, and that leads me, again, I think that I didn't hear this as much from Mr. Holman, but that phrase as appropriate, it seems to me that there are multiple ways you could interpret that potentially.
Correct.
So I'm not really sure that I understand the plain meaning argument here.
And as I said before, that's more in terms of what staff has to come to a decision on what it understands when it's going to review and interpret and try to apply all these rules and statutes. And having been involved in a few rulemakings, a lot of these I see are, artifacts of that process where somebody just had to get this in there. They think it was important, and maybe there was a trade-off in some other area of the rule in order to achieve that outcome, because somebody thought that modifier, I'm guessing, was giving credence to the specific and special lay of the land that applies to gas utilities versus electric utilities. And so that's why I take it that's included there. But I don't believe we have a lot of, we don't do statutory history or regulatory rulemaking history in New Mexico for some reason. And maybe that's a good thing, because I've dealt with it before in other jurisdictions, and it could be just as maddening as trying to guess at the plain meaning of some of these things that get ciphered out for us here in regulation land. So, but I agree. That's the rub of it. And it seems like you have an interesting slate of considerations to make to get this one tied up and resolved. Anything else?
I don't have any further questions for you.
Well, I feel pretty good about this because we're starting to go in circles, and I think we've beaten this poor thing to death. But I will defer to counsel and let him come back up here and take Mr. Microphone.
Thank you, Mr. Bagacco. I appreciate it. And Mr. Haverly, you have 7 minutes for rebuttal.
You, sure. Thank you, Mr. Bagacco. Couple things I'd like to quickly address is that I missed something earlier on, and I went back and double checked, and the question was raised: has there been an order in one of these IRPs that actually accepted it? Yes, actually there was a 12-00145 was the 2012 gas IRP. The commission, there was a protest of that IRP. The protest was ultimately satisfied, and the commission accepted in a final order the IRP that was presented in the 2012. So they did actually enter a final order accepting that IRP. That IRP is very similar to this. It did not have the analysis that is laid out in 11B, which then ultimately goes to where we were talking about as that there's a reason for that discretion. And I think it's also interesting, the statute, as we've been talking about, the statute is really interesting. When you go to 62-17-10, it says you shall evaluate. Amongst those things, it says distributed generation. That's an impossibility for a gas utility. The gas utility cannot add that to the mix. That would and it talks about fuel supply. Well, we don't view it as the gas commodity as a fuel supply. It's what we actually sell. It's the business we're in. It's not a fuel to power anything that we're doing. It is what we actually sell. So when you look at this, and then you take into account all the other rules and regulations that we've talked about, the fact that you have a PGAC requirement, you have energy efficiency requirements, all these other things. I look at this rule and I go, this is actually a really good effort by the experts at the commission to try to harmonize the requirements of an IRP in the realities that the statute is really written more towards an electric program, and then trying to make it applicable to the gas utilities that are functioning in the state, and then taking into account all the things that the commission already has with the purchase gas adjustment clauses, the energy efficiencies, rate cases, all the other things that are also somewhat discussed in statute, but also by regulation and practice. How do you harmonize all of these things together? And this rule does that. This, as appropriate, is a recognition that at one point, renewable energy wasn't even a possibility in the gas side. It is now becoming a possibility, and we are keeping our ears to the ground on it. But at one point, it was not. Energy efficiency matters. Those are all dealt with by the Energy Efficiency Act. They are all governed by regulations. They're put to the test for every 3 years. This rule recognizes that there's a broader framework that's operating in the commission where these things are being analyzed. And again, I bring it back to Mr. Bagako's point, compliance filing compared to what else is going on and what's being litigated. Energy efficiency cases are being litigated. Our PGAC cases are always docketed. That is the prime area for people to come in and talk about what our gas supply is looking like, what we're doing, how we're getting our supplies, how we're actually charging customers. The concern about stakeholders having transparency. Tons of transparency in a PGAC case. We make annual filings with the PGAC, provide tons of information in those. We do monthly filings on the PGAC to the commission and stakeholders saying, here's what everything is lining up. We do a fuel supply plan every year where we come before the commission, we file it, and we come and give a presentation to the commission. What does the whole gas supply look like today? What's it looking like going forward? I think this rule is a great incorporation of the fact that the commission gets lots of information from us and from the company all over the place.
Let me ask you about some of the, what I thought I heard from Mr. Holman and what I definitely heard from Mr. Bagako in terms of, what might be helpful in terms of, even if you don't have to necessarily do the analysis in 11B, to actually explain why, or to say that you hadn't done the analysis, and maybe with a brief explanation as to why. Now you're brief, we talked about it at length this morning about the due process and how it'd be very difficult to have to go back and do that analysis again. But if it's something more like that, it seems to me the due process concerns will be limited based on what you were arguing earlier this morning.
So would it be possible for us to, again, and I agree, organize our IRP better and to provide a point that said 11.74.11B, no analysis for renewable energy because cost prohibitive. This is what the forward markets are looking like. We could do that. I agree with that. We tried to do that, not in the greatest way. I completely understand that and acknowledge that. But we did talk about the fact that renewable energy is not cost effective and that we are in the market all the time. Like I said, we are doing these things. The company is doing these things on a regular basis and knows that those are what that spread of the differential is. So could we have put more facts on that? We definitely could. If that's what the commission would like to see in future IRP filings, we will be very cognizant of doing that. Not a problem.
And just to put a fine point on that, if it is explaining why gas company exercises discretion not to perform an analysis versus doing the analysis itself. From the due process burden analysis, is there much of a burden on gas company?
If it's to simply explain the rationale, because, the company does do an informal analysis of these things to decide whether they even have to go run these models. If it's to provide that, I don't know that would be a due process issue. And if the commission would like some insight as to why we did not provide an analysis of the cost effectability of the load management or other resources, we can do that. Our view was that was heavily litigated in the LNG filing. The commission has tons of information on it, but if the commission would like us to have a quick summary of it, we could prepare something like that, and we could put together why we didn't go forward with a more detailed analysis, the kind that would be in 11B. That would be fine, because I think really the question here for the commission is, does the gas company have to do this analysis and then just simply state that this resource was appropriate, this resource was inappropriate? That is a fundamental shift from what we have done in the past. If it's just explaining why we didn't do an analysis and having it in one spot, we can do that. We can revise that. That would not offend due process. Require us to go back and, because that would just be explaining what we've done. If we have to go and do more things and new things that we have not done and obtain resources to do that, I think that is a greater concern.
And, with the understanding that, this, we're gonna be offering other parties more time, because I want to just ask one more follow-up question on kind of related to what I was discussing with Mr. Bogacco, and the consequences of the due process argument that you're making. So, and thank you for flagging, by the way, 12-145, I believe. So setting aside 12-145, if gas companies' position is that once something is deemed accepted based on commission inaction, that creates a past practice that has cascading effects across commission rules. So this is a bit of a line drawing exercise. How is it after one is accepted, then the commission can't do anything without, a rulemaking or some kind of other outside of adjudicative or outside of an adjudication notice? Is it, after 2 filings, 3, 4, how many instances of a certain filing being accepted as compliance without any commission action does it take for a practice to be created? That's my concern, not just in this case, but all over the commission's rules.
Sure, and that's appreciated, because some of the commission rules are they even operate an advice notice, for instance, where the companies can file tariffs and other things on advice notices. Those become law. I mean, those become binding on the company and the customers, and I can understand why that would be a concern. But I think that it is somewhat dependent, and I hate to say that, because I think it is somewhat dependent about what's in front of the commission as to whether there is a past practice here. I think that 4 or 3 for the gas company previously, and 2 for I believe it's Zia Natural Gas, all that looks similar. Now you have a body of at least 5. I think that definitely qualifies. I think in some instances, you would probably 2 or more is probably the requirement, but I can see where an issue might arise where something was very specific that the commission signed off on and then later said, no, then the ramifications were significant on that reliance. So I hate to do the lawyer trick and say, well, it depends, but I think it really does. I don't think it's going to be a bright line. For a tariff, if a tariff goes into effect and the commission suddenly decides by operation of law and the commission decides it needs to do something about that, it needs to do an investigation, it needs to docket a case, it needs to do something active to tell everybody that these things are going to happen. And I think it's the same type of notice that we're talking about here. If it's going to be changed, that's fine, but there has to be notice to give us all the ability to prepare for and deal with this. And one of the real problems with doing it in this case, doing a complete change, is now what do you do with, as we raised in our brief, what do you do with the other utilities? They're not here, they're not bound by any of this. How does the commission revise its interpretation here and not with them, and how do they get notice? And I think that's a real problem that needs to be dealt with. Thank you, Mr. Haverly.
I don't have anything else. Thank you, Mr. Haverly.
Thank you.
We gave Mr. Haverly 3 additional minutes, so we'll do the same. Mr. Holman, if you want to offer, if you want those 3 minutes, you're welcome to say your piece, or you don't have to use them.
I'll just say 2 things quickly. Mr. Haverly mentioned several other proceedings in which he said that there's a lot of transparency and information distributed about the resources that they are pursuing. And I would just say that those other proceedings are very specific and unique to individual resources. The IRP is the only thing that evaluates all of them on a consistent and comparable basis. So for purposes of trying to effectuate that reality, this is the proceeding in which the utility needs to provide that transparency. I'll leave it there. Thank you.
Okay, thank you. Mr. Bragaco, do you want to offer anything?
Nothing further on the substance. I just wanted to thank you for conducting an efficient oral argument hearing and getting down to the issues. I think we all agree on what the issues are, and I look forward to assisting you in any other ways that you might need before you make your decision. So thank you.
Thank you. Thank you. Okay, well, that concludes the oral argument this morning or today, now that we're past noon. Thank you to everybody, all the parties, all the attorneys for your arguments, and your professionalism today. Just in terms of moving forward, as briefing has already been completed by the parties, I don't think that we will be requiring any post-hearing briefing. So the case can effectively be considered submitted for our review, and a recommended decision to the commission. With respect to moving forward, like we sort of outlined in our procedural order, the hearing examiners now have to determine essentially the options that we have. We can either submit a recommended decision deciding this as a question of law, or proposing to decide this as a question of law directly to the commission, or if we conclude, contrary to what all the parties have stipulated, that there are no questions of fact, if we were to determine that there is one, then we would move this case forward to a second stage. As part of that, we would certainly issue a written decision so that you would see why we conclude that there's a need for a second stage, as far as what those issues were that would need to be determined that way. But either way, you'll receive our order, or either a recommended decision or an order from us. Are there any questions from the parties as far as the procedures going forward?
Sir. Yes, sir.
Okay. Mr. Holman, any questions at all?
No, thank you.
Okay, thank you. So are there any final issues or items that we need to address before we adjourn and go off the record today?
From the company standpoint, I don't believe so.
Okay.
Nothing from staff. Thank you.
Okay, and Mr. Holman, anything from WRA or CCE?
Nothing from us. Thank you.
Thank you. All right, seeing none, thanks again to everyone for your professionalism. We are now adjourned and off the record. Thank you. Thank you, Ms. Hoyman, for your help today. We really appreciate it.
Thank you, Mr. Hearing Examiners.
Thank you very much. And I'm